So you have your unique, great business name, but as an artist, you have to think about, do I need to protect my business name and my logo, or am I too busy making art and I don't want to worry about that right now? Well, we're going to talk about today is a little bit about what a trademark is, how to distinguish it from a copyright and a patent, whether or not you actually need one, how to get one, what happens if someone's infringing on your trademark, and we're also going to talk about our personal trademark story. All of that stuff is in the boring agenda over here, or it might be over here, one of the two. Let's get into it. So first thing is, what is a trademark? So a trademark protects distinctive words, phrases, symbols, sounds, or designs to identify or distinguish a source of goods and services between two parties. So that's the important thing, is to distinguish. Examples of what a trademark is a company name, a logo, slogans or catchphrases, a figure or mascot, or even lyrics. But lyrics is just in a limited form. So for example, the Chevy Like a Rock commercial, that like a rock part can actually be trademarked. But there are also things you can't trademark. So a trademark must indicate the source of origin and distinguish those from another through the lens of how it is perceived by the public. If it is just a word that merely conveys information about goods and services, like tissue paper or the tissue paper, that's not enough. But if you have a unique word like Kleenex, then that actually distinguishes it from other tissue paper. Widely used messages are not able to be trademarked. So the golden rule or the word thank you, you're not able to trademark that. And direct religious quotes, passages, and citations also cannot be trademarked. We get a lot of confusion between what is a copyright, patent, or trademark. So these are the kind of distinctions that I've been able to lay out. So starting off with a copyright, that protects original works of authorship. So if you're an artist, your actual painting, or your play, if you're a playwright, that you would get a copyright for that. So examples: literary, dramatic, musical, artistic, poetry, novels, songs, software, architecture. You file this with the US Copyright Office. The time limit for expiration is 70 to 125 years. A patent, on the other hand, is of limited duration, and that's a property right to an invention. So if you came up with a new way to do watercolor, or a new sublimation method using unique paints and methods. So examples of that: machines, algorithms, manufactured products, industrial processes, or chemical compositions. You would file this, on the other hand, with the US Patent and Trademark Office and not with the US Copyright Office. The time limit for these is usually 15 years if it's a design, or 20 years for a utility. There's all these other exceptions, but this is at a very high level. A trademark, which is what we're talking about today, is protecting distinctive words, phrases, symbols, sounds, etc. to distinguish the source of goods and services between two parties. For example, your company name and logo, or a campaign slogan. You would file this with the US Patent and Trade Office just like a patent. Expiration date for this is none. You do have to do some filings here and there, but for the most part, McDonald's is going to be trademarked in perpetuity. Do you need it? Should you stop doing your art and actually get after this administrative thing that you've been putting off? In general, sooner rather than later is recommended. However, a protection for your trademark arises automatically from the time there is actual legitimate use of your mark for business or commercial purposes. That may be when you sell your first commission and you put the name of your company on the invoice. In general, the first to use a mark in commerce or file and intend to use the application with the USPTO wins. So if both of you guys come up with Kathy's unique art business at the same time, but someone files it first with the USPTO before the other person, then that person would win. Or the first person to use it in commerce, for example, the invoice example, that person would win. Considerations of why you should do it sooner rather than later is that the USPTO trademark process is not guaranteed. There might be hangups, there might be misfilings, they might not understand it, there might be other trademarks that are too similar. You want to build in some cushion for that process. Also, someone may have already trademarked the name that you're trying to use, or the domain may already be taken up and you want that kathysuniquecompany.com URL. So how long does a trademark last? In general, it lasts 10 years with 10-year renewal terms. However, you do have to file an affidavit that you are still using it between the 5th and 6th year. It's coming up for us, so I hope I don't forget. How do I get a trademark? So the first thing is that you don't need an attorney to do it. How do I know? It's because I'm an attorney, and like I always say, we're useless. We are overpaid administrators, and sure, you can find an attorney to do it for $150 an hour, $300 an hour, or a flat fee of $500 to $1,000. By delegating it to an attorney, have the peace of mind that they'll take care of it, and you can just focus on your art and not have to worry about that. However, by doing it yourself, you get to deal with the US Patent and Trademark Office. I know you guys always love dealing with the federal government, but you just fill out a form and you go for it. In general, the process is you go to TESS, T-E-S-S, which is the database to search the name you want to trademark is already taken or anything similar to that. After that, you fill out the online forms and then you pay some money for the filing fee. And it usually ranges anywhere from $225 to $400, depending on what type of trademark you are filing. So the fun part, what happens if someone is infringing on your trademark? So using the use case of Kathy's unique company, if someone else is using Kathy's unique property. Let me lay out the options that you have. First thing you can do is do nothing. It's not bothering you too much. You got other stuff to do. Just go ahead and leave it and whatever. Hopefully they don't sue you. You're not going to sue them, and you kind of just move on with your life, and hopefully they don't turn it into a real competitor or too big of a company. Second thing you can do is send a cease and desist letter. So what this is just a letter saying cease, stop, and desist from using this trademark or else I'll sue you. You don't even have to write the proof that you have, but you usually say like, I've been using this, I already filed this, and if you don't stop using it, then I'll make your life very difficult and sue you for lots of money. And hopefully it puts the fear of God in them, and then they're like, I don't want to get sued by you, and they stop. In some cases, if the person that is infringing on your trademark is really bold, then they'll ignore your cease and desist letter, because at the end of the day, it's just a letter. So the next thing that you can do is you can sue them, but are you really going to sue them? Things to consider when you file a lawsuit against another person is that, do you have the time and money to sue someone? You can hire a lawyer to do it. To just get a retainer for an attorney, it can cost $5,000, $10,000, $15,000, and they bill against that retainer for $150 to $300, $500 an hour. So it gets really expensive to protect your trademark. So usually the court system is usually used by very wealthy people in order to protect their rights. But for normal artists, if you happen to not be wealthy, suing is probably not the best option. On top of the financial, time, and emotional costs, there's also the statute of limitations. You have to make sure you file your lawsuit within a certain amount of time, otherwise you lose your rights. It all depends on what state you're in. You also have to have proof that you are the owner of that trademark and you have rights in that trademark. And part of that proof is whether or not you filed it with the USPTO, or you have proof that you were the first one to use the trademark in the regular course of business. And after all is said and done, after you spent thousands of dollars or hundreds and thousands of hours and stressed out over this process, you win. But is it really justice? I don't know. It depends on whether or not you can prove damages. Even if you can prove damages that you're entitled to thousands or hundreds of thousands of dollars, if the company just files for bankruptcy and can't pay you anyway, then I'm not sure whether or not that's justice. So that's a long rant on the civil litigation process, but things to consider when you're thinking about suing someone for trademark infringement. So just so you see an example of a trademark, we will show you the Easy Sunday Club trademark. So we are going to the USPTO website and going to the test system, Trademark Electronic Search System. And we're going to do a basic word search, Easy Sunday Club, enter. You can put in McDonald's or look at one of those examples, and you'll look at our trademark, which is the turtle logo, as well as the word mark that says Easy Sunday Club. And you can see some of the description language here that you have to fill out in the application. So if you look at the mark drawing code, it says design plus words, letters, and or numbers. You can see the filing date. You can also see the description that it's a tortoise or a turtle. So it's pretty straightforward. So once you're done with your filing, this is what you'll get. That's a little walkthrough for Trademark 101. Let me know what you think. If you have any comments, please put them below. I'll do my best to answer without giving legal advice, and this is just strictly for informational or entertainment purposes. We always appreciate your support and kind words. Go ahead and hit that like button if you feel like it, and subscribe if you want more content like this. Thank you very much.